Sure, sir. We are Team E. I am one of the officers. For the sake of the record, Your Honor, there are 3 points which I would like to clarify.
What is your college name, please?
Shivaji Maratha Law College.
Pardon, sir, I couldn't hear you properly.
Your college name, please.
Are we permitted to disclose our college name, sir?
No, see, I have to. No issue. You can have no issue because see, for the sake of team and team, instead of I am just mentioning the college name. No issue. You can argue.
Okay, sir. For the sake of the record, there are 3 points which I would like to get the permission.
You will discuss who will be first mooter, who will be second mooter, who will be researcher.
I am the first mooter. I'll be mooting on behalf of the. I'll be arguing the case on behalf of the appellant, Mr.
Okay.
Vikram. There is a second mooter who is visible on the other screen.
Vikram Bhosale.
Correct,
Yes.
sir. I myself Ravi Shankar,
Yes. Okay.
and the researcher
And the
is Tushar Ramteke.
Yes, I'm the researcher. You can see me.
Okay.
Thank you.
Yes. Researcher, I am not actually seeing. Just show the face of researcher.
1 second, sir. Sorry, his camera is not on.
Yes, can you see me?
1 second. Hello.
Can you see me?
Yeah, all right. I am able to see. Sir.
He has not been keeping well, sir. So he's got his jerkin on.
Please proceed.
Yeah, very good afternoon, Your Honor. For the sake of the record, there are 3 points which I would like to get your permission. First and foremost, we are pleading in the presence of an Honorable High Court. So we be granted to plead our case sitting down. I seek your permission to do the same.
Please.
The second point is, as per the rules laid down by the Bar Council, we are supposed to have a gown on, but since the rules have mentioned only a coat, so we are restricted using the gown. So again, we seek your permission, sir.
Apparently relaxed so far as gown is concerned.
Okay. And the third and the most important in the present times,
See, if you mentioned court etiquettes. Court etiquettes. Due to COVID also, we are also appearing day-to-day before the High Court. I will try and the blazer of court.
okay, sir.
Okay.
And for
If you
the
maintain the court etiquettes, also that will be okay also.
for the sake of audio clarity, we are not using the mask.
So,
Sure, sir. May I proceed with the case, sir?
yes.
So with the Honorable Court's permission, since already the facts are available on record, I won't take the time to go through the facts, various facts. So under the circumstances, may I please directly go to the issues?
No, as per the rules of moot court, you have to. Then I will make you able to understand articulations, your way of language, pronunciation, how to write. Please.
Sure. In that case, this is our first participation in the moot court, so we are not much aware of the technicalities involved, sir.
Please.
On behalf of the appellant, the various facts that is available on record, going by the serial number wise, Mr. Rohan, an Hindu, aged 48 years, was pioneering smuggling of gold and diamond and was popular in the city of Bombay. The second fact is Roshan, a Christian, aged 46, was a close associate of Rohan and was supporting his business dealings by receiving commissions. He would be either a sort of a middleman or he deals with the smuggled goods and he was getting commission. The third was Rashid, a Muslim aged 45 years, a local leader and a politician, and he was known in the area as a Gundagiri Badshah, and was an associate of Mr. Roshan by supporting his illegal activities. The next fact is the partnership firm called Diamond Gold Exports Private Limited was started in the area of Chor Bazaar in Kalba Devi, Mumbai on 1st of April 2015. This partnership firm has been registered in the said name and the agreement to share the profit and loss at 1/3 each. That means all the three partners mentioned right now, they all agree the equal shares. Mr. Ranjit, aged 22 years, was the son of Mr. Rohan, and he had completed his MBA in California University and was appointed as a manager in the above said partnership firm in the year 2017. This is again a fact. Mr. Ranjit, being unmarried and having handsome looks, he fell in love with one Miss Kranti who had done her BE, and she was aged 21 years and is the daughter of Roshan. The next fact is Mr. Ranjit being unmarried and Miss Kranti also being unmarried was deemed to be an illicit relationship. This illicit relationship is a fact which has been mentioned in the as a part of the having learnt of this illicit relationship, Mr. Roshan fixed CCTV cameras in the house without the knowledge of others and thereafter traced the footprint record and opposed this relationship to that extent, informed the father of Mr. Ranjit, Mr. Rohan. This led to a confrontation of Mr. Ranjit on one side and Mr. Roshan and Mr. Rashid on the other side. This is also a fact. That means already two varying parties got generated because of this relationship. On 31st night, that is of December 2020, at 11 p.m., Mr. Ranjit started for Goa to celebrate the New Year celebrations. This fact was not known to even his father, Mr. Rohan. But Mr. Rohan and Mr. Rashid, they were keeping tabs on Mr. Ranjit's movement and both had pre-planned to attack Mr. Ranjit by arranging gangsters. This is also a part of the fact. Two cars deemed to have followed Mr. Ranjit from Mumbai, and when he reached Uran Highway, he was attacked with weapons like pistol. Now, the actual crime scene happens. A firing sound was heard by a local resident who was having a tea shop 50 meters from the place of the crime scene. The local resident, as witness, was unable to identify the car number and people sitting inside the car. The incident took place between 11:45 p.m. on 2020 night and half an hour past 12 night on 1st January 2021. Those attackers, deemed to be attackers, but the fact is those attackers ran away from their cars. The public gathered and after a few minutes and noticed blood flowing out of the body and immediately shipped Mr. Ranjit to Uran Hospital and was found dead during the course of journey. On receiving the information from the public about the incident, the police rushed to the hospital directly. This is also a matter of fact. The doctors removed 2 bullets from the body and post-mortem was held subsequently. This news is deemed to have been in the local newspaper and TV channel. The local police was unable to trace the gunman, Mr. Rohan, the father of Mr. Ranjit. He filed an FIR with the local police authorities and also filed a private complaint. Subsequently, the court for investigation. This is also a fact. The court ordered for CBI investigation about this case. The CBI started to investigate the matter and arrested Mr. Rohan and Mr. Rashid along with 2 gunmen with the driver and the cars of the gangsters. This is again a matter of fact. The CBI have recovered 2 pistols and sharp instruments like sword, knife, etc. The CBI filed a charge sheet in the court. The district and sessions court ordered death sentence to one of the 2 gunmen and life sentence to all the other 4 involved in this case. The accused had preferred an appeal before the judicature of Honorable High Court, Mumbai. So this is all the 24 facts have been laid out, and now we would go to the next, the statement of issues, framing the issues. Shall I proceed, sir?
Yes, yes, please.
Thank you. Issue 1. Whether the quantum of punishment given to all the 5 accused justified. From the appellant point of view, sir, my argument in advance would be in the negative. The Honorable Tri-Court has committed an error in passing the impugnment order, thereby convicting all the 5 appellants. There is no evidence which incriminates the appellants to have committed the said crime based on the relevancy or irrelevancy of the facts. Thus, the quantum of punishment granted to each of the appellant is not justified. That is, even for an example, if I have to quote, a driver who was only driving the getaway car is given the same quantum of punishment as that of the main accused. That is either Mr. Roshan or Mr. Rashid. Now, whether I go on to the next issue, second issue, whether the deposition of the prosecution witness of any relevance. The only prosecution witness is of no legal relevance in this matter, since the witness has not witnessed the crime in the happening. As a matter of fact, the witness was 50 meters away and it was night time. The witness has only heard what he assumes to be a gunshot, which could otherwise be also a firecracker being burst by somebody, being a New Year's Eve. Hence, whatever the prosecution witness heard and deemed to be a pistol shot may be hoax. Also, moreover, that it doesn't imply that the accused have fired the murder weapon. The prosecution witness claims to have seen a car drive by, but is unable to identify the vehicle by its registration number. The said prosecution witness also was not able to identify any of the people traveling that said getaway car. So, keeping in view all these points, the relevancy of the prosecution witness deposition as an evidence is not of any legal importance in this particular matter. Hence, it shall be fair to state that the Honorable Trial Court has relied on deposition of a prosecution witness and evidences which are totally unreliable while passing the said order. Now, I go on to the next third issue. Whether the concerned police station investigated the said matter at all. When Mr. Ranjit started from Mumbai to Goa, 2 cars had followed Mr. Ranjit. This is a fact on record. The prosecution witness claims only one car went past him. The prosecution also claims that the accused have deserted the cars and ran away from the crime scene. This is also a matter of fact. If it was so, then why did the police authorities not impound those cars from the crime scene? It's a matter of question. But the concerned police authorities have not taken cognizance of the FIR as submitted by the father of the victim, that is Mr. Rohan. Subsequently later, the CBI claimed to have arrested all the accused and the cars of the gangsters. The police also claimed that the gunmen were not traceable. This is again a matter of fact. But the CBI claimed to have arrested the gunmen. The facts as to two gunmen being present to commit the crime is contradictory to the various facts involved here. Hence, this fact as evidence highly questionable. Now I come to the fourth issue, whether the post-mortem done as per procedure. The prosecution witness, he had only one shot being fired, but the doctor claimed to have recovered 2 bullets from the victim's body. This is again a fact. The victim was taken to the hospital by the public and the victim died on the way. Thus the victim reached the hospital in a dead on arrival condition, what normally the doctors call as DOA in a short form, with bullet wounds. This amounts to a medico-legal case. Again, this is a fact. The death of the victim is known to have occurred as a result of criminal activity when brought to the hospital. As a procedure on arrival, an OPD doctor examines the victim to check whether the victim is dead or alive. If the victim is alive, then he or she is taken to the concerned department or operation theatre immediately for medical treatment. Yes, sir. You understand?
I said you are actually running late in the time because I have already mentioned in chat box 10 to 12 minutes for each person.
So we didn't get that message, sir. Sorry.
Can you see the chat box?
Okay, sir. Sorry. I did not notice it. We will.
Directly you come to ultimate info of your appeal.
Sure.
So it will, it will conclude your entire.
I have got only another 2 more issues and
Okay,
I will
please.
wrap up my case, sir.
Because see, this is a moot court and you have to be in time.
Sure.
It is like test match versus T20.
Absolutely, sir. Sure.
Please.
Coming back to the same issue number 4 in continuance. Now, whether the Uran hospital is a government hospital is not stated in the prosecution statement. The post-mortem should have been done by a forensic pathologist who is competent authority, and as per the section 45 of the Indian Evidence Act, to investigate deaths where there is a medical legal implication, and this was not done as per procedure. Hence the OPD doctor removing the bullets before the post-mortem procedure is totally wrong. Now coming to the fifth issue, whether the trial court passed the order for CBI to investigate the same matter as per stipulated procedure, it is in the negative. The order passed by the Honorable Trial Court is misconceived and procedurally wrong. In case of any case pertaining to Prevention of Corruption Act, the state government's permission is required. But in this case here, unless only the High Court and Supreme Court has the authority to ask the CBI to conduct the investigation, the Sessions Court do not have the powers, discretionary powers to do so. A very famous case law of Dharmendra Deo Mishra versus Central Bureau of Investigation is attached as a reference to it. Hence, it will be fair to state that the Honorable Trial Court has passed a perverse order in total violation of section 156(3) of the CRPC. Now, sixth point is where the fundamental rights of the victim has been violated, it's in the negative. The Honorable Trial Court has considered the Article 21, subsection 7 of the Constitution of India and has passed the relevant orders. Thereby, the fundamental rights of the victim has not been violated by this Honorable Court, Trial Court. Whether the relationship of the victim, Mr. Ranjit and Ms. Kranti, in violation of any laws prevalent, again, in the affirmative here, Mr. Roshan, the father of Ms. Kranti, had informed Mr. Rohan about the illicit relationship of Mr. Ranjit and Ms. Kranti. As the father, Mr. Roshan's operation about his daughter is not misconceived, and as a father, he has all the rights to guide his daughter in the process of selecting the correct life partner. But installing a CCTV camera, it is in violation of Article 21, subclause 6, thereby snooping on his own daughter was not prescribed. So now I am coming to the final.
Because you already crossed near about 15 minutes.
Yes, sir. I am directly going on to the prior clause, sir. I'll read the prior. Since along with the issues, I have already argued my points, I'll go to the prior clause. Keeping in view whatever stated in the facts, issued, raised, and the arguments advanced, it is hereby I pray that on behalf of the appellants, the conviction of the appellants is nothing but a miscarriage of justice. Hence, the said order of the District and Sessions Court be set aside. I also hereby pray that the order of the trial court be stayed as per section 389(1) of the Code of Criminal Procedure 1973. And also, I pray to this Honorable Court that any other order under natural justice and equity and good conscience in favor of the appellants be passed. I respect it, sir. Thank you.
Please. Yes. Mr. Counsel for respondent.
Yes, Honorable High Court, I am appearing on behalf of respondent. Please grant me to start proceeding. May I proceed?
Please proceed.
Court have already knows the all facts. If court permit me, may I raise the issue directly?
Please, because your first Mr. has already given a facts.
Yes, thank you very much, sir. First issue, whether the quantum of punishment given to all the 5 accused justified in relationship to the crime. In the negative, the Honorable Trial Court has passed the death sentence to only one of the 2 gunmen. The main perpetrators of the heinous crime, that is the accused number 1 and accused number 2, both have been awarded to life imprisonment. The evidence as to whole pulled the trigger is not clear, since 2 bullets have been extracted from the body of victim. It would be prudent to conclude that both the gunmen pulled the trigger at the same time, thereby the prosecution witness hearing only 1 gunshot. Hence, both the gunmen should be awarded death sentence. Issue number 2, whether the disposition of the prosecution witness of any relevance in the affirmation. The deposition of the prosecution witness is totally in favor of the respondent, hence it is of the absolute relevance as per section 6A and section 7B of Indian Evidence Act. Also section 8. It's an important section, sir. If we looking out that section, so we understand that motive, preparation and previous and subsequent conduct, that is all points are need to consider. So issue number 3, whether the concerned police station investigated the said matter at all. So in the negative, the concerned police authorities have not taken cognizance of the FIR submitted by Mr. Rohan. Thereafter, Mr. Rohan had filed a private complaint in the court of law. The police authorities, when informed by the public about the said crime, instead of rushing to the crime scene, went to the hospital. Keeping in view this fact, the Honorable Trial Court deemed to important to hand over the said matter for investigation of the CBI. Then issue number 4, whether the post-mortem done as per the procedure in the Affirmation. The OPD doctor had removed 2 bullets from the body of the victim as per section 45. It point to be noted, my lord, of the Indian Evidence Act, the very fact of the bullets being extracted from the victim indicates that the victim was murdered in the cold blood. Any procedural method adopted by doctors in the investigating and medical legal case, it is a matter of internal concern of the hospital, and this may vary from the hospital to hospital depending on the availability of the staff and doctors. Here we not neglect the essential of murder and also not ignore the natural justice. Then my next issue is whether the trial court passed the order for the CBI to investigate the said matter as per the stipulated procedure. In the affirmation, the concerned police authorities have not taken cognizance of the FIR as submitted by Mr. Rohan. Thereafter, Mr. Rohan had to file a private complaint in the court of law. The police authorities, when informed by the public about the said crime, instead of rushing to the crime scene, went to the hospital. Keeping in view this fact, the Honorable Trial Court deemed it important to hand over the said matter for the investigation to the CBI. Here I need to mention also here my submission is appellant number 2, Mr. Rashid, a politician leader and also so-called Gundagiri Badshah. Hence, local police came influence of him. That's why I was going to individual court, and according to circumstances in this case, subordinate court ordered to investigation to CBI. As further, I lost my son, Mr. Ranjit, where Ranjit right to life was one of the basic human right, and not even the state has the authority to violate that right. Then my next issue is whether the fundamental rights of the victim has been violated. In the affirmation, the Honorable High Court of Mumbai has all the rights of here appeal under Article 226 and 227 of the Constitution of India, and also under Section 374 subclause 2, 389 subclause 1 of the Code of Criminal Procedure Code 1973. Then the Article 21(7) subclause 7 of the Constitution of India state that right to life is one of the basic human right, and not to even state the authority to violate right. This is the evidence of this supportive case law is a Siddharaman Satlinga Maitre versus State of Maharashtra, JT 2010. The life of Mr. Ranjit at the prime young age of his life was extinguished by the accused. Thereby the right to life by Mr. Ranjit has been denied to him. Thus it is the total violation of the right to life. My second last issue, whether the relationship the victim Mr. Ranjit, my last issue, whether the relationship of the victim Mr. Ranjit with Miss Kranti in the violation of any prevalent in the affirmation. Mr. Ranjit and Miss Kranti were single, unmarried individual, and they were measured by age. Hence, as per Article 21 subclause 10 of the Constitution of India, if a boy and girl wishes to get married by their own will, and if they are measured, then no one can prevent their relationship. Hence, the father of Miss Kranti, Mr. Roshan, in abatement with the other accused, have committed the heinous crime of killing Mr. Ranjit, thereby have violated his fundamental rights. So, lastly, my prayer, keeping in view whatever stated as fact, the issue raised and argument advanced and authorities cited, it is hereby prayed that the quantum of punishment of the appellant number 2, 3, 4 and 5 is not justified to the heinous crime committed. Hence, this is a nothing but miscarriage of justice. Hence, the quantum of punishment should be increased for the accused number 2, 3, 4 and 5. That any order that any deems fit in the interest of natural justice, equity and good conscience in favor of the respondent. That's all, Your Honor, and thank you so much.
Mr. Second Number, you actually required to cite more judgment because you are on behalf of your applicant for prosecutions. So your case must be supported, was required to be supported by more of the judgment on the capital punishment, more of the judgment on the life judgment. None of the authority has come forward. And secondly, I think you just mentioned Article 21 subclause 10. There is no subclause 10 to Article 21. Article 21 is this sentence: no man shall be deprived of personal liberty except the procedure established by law. That is what is in Article 21. This is 10 clause. So while arguing before the court, you should bear in mind that you should know the procedure provision first. Don't try to argue before the court aside wrong provisions.
Actually, no, I am taking this from this, and here mentioned.
And you look at the Article 21. Article 21 is simplicity two sentence.
There is only
No
one-
person shall
there
be
is one-
deprived of his personal liberty.
Okay.
Yes, protection.
Okay, sir.
Personal.
There is no subclause.
Okay, sir.
No? And otherwise, for example, your skill of advocacy, framing of issues is fantastic well.
Yes, sir. Thank you, sir.
No issue.
Thank you, sir.
And but you are lacking in core paper because one of your, though you have mentioned the cited the reasons of illness, but that may reduces your mark. So far as core etiquette and bar council of physical ratio is concerned.
Okay, sir. Thank you, sir.
And
Thank you.
the hospital also actually was required to cite more authorities because I don't find it is argument. The authorities on this are the basis of which we could demonstrate the conviction is not sustainable.
Okay, sir. Thank you, sir. Thank you, sir.
Your team has done fantastically well.
Thank you very much.
Yes, sir.
Thank you, sir.
Yes, yes.
सर एक लिंक दिली आहे काही कंपनीचं आहे
Sir, who is there from the management section? Anil sir. Yeah. You can 10 minutes because since from 2 hours I am speaking for the.
ओके ओके शुअर सर मी स्टुडंटला